Good morning, my name is Bata Pollock, and today I would like to discuss promoting and protecting human rights within the UN system. Within the UN, the bodies responsible for promoting and protecting human rights can be divided into two main categories. Those that derive their authority from the UN Charter itself, known as charter bodies or chartered-based methods, and those bodies that have been created under various human rights treaties, which are known as UN treaty bodies. To understand the relationship between UN and human rights, we need to first discuss briefly the United Nations organization itself. UN was established in 1945 after the Second World War, and its foundational document is called UN Charter. The UN Charter established purposes, governing structure, and principal organs of UN. UN Charter was signed in San Francisco in 1945 by 50 of its 51 original member states. At the time of the San Francisco Conference, Poland, one of the original signatories, right after war, was going through a very difficult phase, was taken over by communists and did not have its government. On June 28th, the new Polish government was announced. And by October 1945, Poland had signed the charter that was written in San Francisco, and it's therefore considered as one of the original members of the new UN. UN Charter consists of preamble, 19 chapters, and 111 articles. Organs under UN Charter are the General Assembly, Economic and Social Council, Security Council, International Court of Justice, the Secretariat, and the Trustship Council. The Trustship Council was suspended in 1995, so we will not discuss the function of Trustship Council today. In the preamble to the UN Charter, we can find the reason why UN was established. So we can read that we, the peoples of the United Nations, determined to have succeeding generation from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, and to reaffirm faith in fundamental rights, in the dignity and worth of the human person, in the equal rights of men and women, and of nations large and small, and establish conditions under which justice and respect for the obligation arising from treaties and other sources of international law can be maintained, and to promote social progress and better standards of life in larger freedom. We all know that UN is a successor of another organization, League of Nations, which was created after First World War. We also know that League of the Nations was not a success and could not fulfill its function. Which was to maintain peace and security. And Second World War happened. In the Article 1 of UN Charter, we can see the purposes of United Nations. And the purposes of the United Nations are to maintain international peace and security, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of people, and to take other appropriate measures to strengthen universal peace, to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedoms for all, without distinction to race, sex, language, or religion. And the last purpose of UN is to be a center of harmonizing the action of nations in the attainment of these common ends. The following Article 2 establish the principles of UN, which are sovereign equality of all its members, settling dispute in peaceful means, principle of good faith, or prohibition of using force in international relations. There is one more important article which we should mention right now, and we will get back to this article later on, especially when we are discussing the relation between UN and protection of human rights. Article 2.7 states that no state nor the UN may intervene in matters which are within the domestic jurisdiction of any state. Article 55 and 56 of UN Charter are considered as a basis for the UN human rights activities. Article 55 states that within a view for the creation of conditions of stability and well-being which are necessary for peaceful and friendly relation among nations, based on respect for the principle of equal rights and self-determination of people, the UN shall promote a higher standard of living, full employment, and condition of economic and social progress and development. B, solution of international economic, social, health and related problems, and international cultural and educational cooperation. And C, universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion. Article 56 states that all members pledge themselves to take joint and separate action in cooperation with the organization for the achievement of the purposes set forth in Article 55. The question could be why this construction of Article 55 and 56? During the conference in San Francisco, it was noted that UN should contain some sort of Bill of Rights, but because of lack of the time during the conference, and also to make sure that the document is flexible enough that all states will join, and also consider the principle of sovereignty of all states, as well as mentioned before Article 2.7, this idea was not moved forward. Article 55 and 56 were included in UN Charter to make sure that so-called protection of human rights is in the scope of UN organization. So coming back to the UN organs, once more, let's list them all. We have a General Assembly, the Economic and Social Council, the Security Council, the International Court of Justice, the Secretariat, and the Trustship Council. Starting with the General Assembly is the main deliberative, supervisory, and reviewing organ of the UN. It is composed of representatives of all member states, each one having one vote. Most decisions are reached by simple majority, while decisions on important questions such as peace, admission of new members, and budgetary matters require 2/3 majority. Article 10 of UN Charter states that the General Assembly might discuss any questions or any matters within the scope of the present Charter, or relating to the powers and functions of any organs provided for in the present Charter, and except as provided in Article 12, may make recommendation to the members of the UN or to the Security Council or to both, and any such question or matters. The General Assembly competence to explore issues concerning human rights is almost unlimited. Article 10, as we notice, is allowing to discuss any question or any matters related within the scope of the present Charter, and to make recommendation to member states on all this subject. All human rights bodies ultimately report to the General Assembly. Even Security Council must submit annual reports to the Assembly. Article 13 of the UN Charter states that the General Assembly shall initiate studies and make recommendations for the purpose of promoting international cooperation in the political field and encouraging the progressive development of international law and its codification, and promoting international cooperation in the economic, social, cultural, educational, and health fields, and assisting in the realization of human rights and fundamental freedoms for all without distinction to race, sex, language, or religion. So just to summarize, General Assembly functions are to initiate studies, making recommendations, promoting international political cooperation, development and codification of international law, the realization of human rights and fundamental freedoms for all, international collaboration in the economic, social, cultural, education, and health fields. Especially the point of development and codification of international law should be elaborated here. So as we all know, General Assembly recommendations are not binding, but they create the so-called soft law. We can list a few very important resolutions of General Assembly. related to human rights subject. We have, for example, resolution from 1916 on granting of independence to colonial countries and peoples, declaration on the elimination of all forms of intolerance and discrimination based on religion or belief, basic principle for treatment of prisoners, declaration on the elimination of violence against women. So as we just said, General Assembly resolution and declaration are not binding, but they are of significant importance. Some codify existing international practice, others contains rules which are agreed by the member states and form new rules of international practice. Most of the major UN treaties on the human rights were preceded by declaration of the General Assembly. The main examples are Universal Declaration of Human Rights, which was later developed in International Covenant on Civil Political Rights and in International Covenant on Economic, Social and Cultural Rights. Declaration on the Rights of the Child from 1959, which later was developed into the Convention on the Rights of the Child in 1989. Declaration on the elimination of all form racial discrimination, which later on turned into Convention on the elimination of all forms of racial discrimination. Declaration on the elimination of discrimination against women, which turned into Convention on the elimination of all forms of discrimination against women. Also declaration on the protection of all persons being subjected to torture and other cruel, inhuman or degrading treatment or punishment, which turned into Convention against torture, and declaration on the protection of persons from enforced disappearances, which turned into Convention for the protection of all persons from enforced disappearances. Coming to the next UN organ, we'll discuss the Economic and Social Council. Article 62 states that the Economic and Social Council might take or initiate studies and reports with respect to international economic, social, cultural, educational, health, and related matters, and might make recommendation with respect to any such matters to the General Assembly, to the members of the UN, and to the specialized agencies concerned. It might make recommendation for the purpose of promoting respect for all and observance of human rights and fundamental freedoms for all. It might prepare draft convention for the submission to the General Assembly with respect to matters filing within its competence. It might call in accordance with the rules prescribed by the UN international conferences on matters filing within its competence. Article 64 of UN Charter states that the Economic and Social Council might take appropriate steps to obtain regular reports from the specialized agencies. It might make agreements with the members of UN and with the specialized agencies to obtain reports on the steps taken to give effect to its own recommendation and to recommendation on matters failing within its competence made by the General Assembly. It might communicate its observation on these reports to the General Assembly. To summarize, ECOSOC receives all the reports of the main international human rights bodies, including the UN treaty monitoring bodies. Moreover, it coordinates various UN programs which aim at improving human rights standards. The example of this program will be United Nations Development Program. ECOSOC can also establish functional commissions. At this moment, we have 8 functional commissions of ECOSOC: Statistical Commission, Commission on Population and Development, Commission for Social Development, Commission on the Status of Women, Commission on Narcotic Drugs, Commission on Crime Prevention and Criminal Justice, Commission on Science and Technology for Development, United Nations Forum on Forests. Previously, we also had a Commission of Human Rights. One of the first tasks of the Commission was to draft the Universal Declaration of Human Rights. In 2006, the Commission of Human Rights changed into a separate body called Human Rights Council. Now we will briefly discuss Human Rights Council. We should not confuse Human Rights Council with the Human Rights Committee, a body established to monitor the International Covenant on Civil and Political Rights. Human Rights Council was established in 2006 and is a successor of Human Rights Commission. Human Rights Commission was originally tasked with drafting the Universal Declaration of Human Rights, and Human Rights Commission fulfilled its task under the leadership of Eleanor Roosevelt with its first year of operation. Perhaps this will remain the most significant achievement of the Human Rights Commission. Human Rights Council functions. Human Rights Council is responsible for promoting universal respect for the protection of all human rights and fundamental freedoms for all, without distinction of any kind and in a fair and equal manner. Human Rights Council should address situation of violation of human rights, including gross and systematic violation, and make recommendation. It should also promote the effective coordination and the mainstreaming of human rights with the UN system. The work of the Council shall be guided by the principles of universality, impartiality, objectivity, and non-selectivity, constructive international dialogue and cooperation, with a view of enhancing the promotion and protection of all human rights, civil, political, economic, social, and cultural rights, including the rights to development. One of the most important tasks of Human Rights Council is undertaking a universal periodic review called UPR. Universal periodic review are based on objective and reliable information of the fulfillment by each state of its human rights obligation and commitments in a manner which ensure universality of coverage and equal treatment with respect to all states. The review shall be cooperative mechanism based on an interactive dialogue with the full involvement of the country concerned and with consideration given to its capacity building needs. Such a mechanism shall complement and not duplicate the work of treaty bodies. The Council shall develop the modalities and necessary time allocation for the Universal Periodic Review mechanism within 1 year after the holding of its first session. Just to summarize the Universal Periodic Review, in the Universal Periodic Review, all states must report to the Council on every 4 or 5 years on their human rights compliance. States compile a report themselves along with other materials, and then it is considered by other states. No state is going to condemn itself, although some states are quite often pointing the problems they face and also showing the solution, how they have tried to address the problems related to human rights in their countries. Now we will briefly discuss the International Court of Justice. We have two international courts. The first, it's International Criminal Court, which is discussed in the other lecture. And the second is International Court of Justice. The ICJ was established in Article 92 of the UN Charter as the principal judicial organ of the UN. It sits in The Hague, in the Netherlands, and it's a successor of the Permanent Court of International Justice. Only states might be parties in cases before the courts. However, the International Court enjoys consensual jurisdiction. States might accept its jurisdiction, either in respect of all or any specific case. A number of cases have significant impact on human rights. Only serious cases are being held in front of International Court of Justice. The cases which concern the most serious aspects of international human rights, usually crimes against humanity and genocide. In 2008, for example, the first case concerning a core human rights treaty was lodged with the International Court of Justice. The case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination. It was a case Georgia versus Russian Federation. Now we will discuss the special mechanism or special procedures within the UN system. The Commission on Human Rights created what are generally known as special mechanism or special procedures The Human Rights Council mandated numerous experts to study particular human rights issues. These experts, which are often university law professors, human rights activists, or judges which are global reputation, constitute what are known as the UN Nation Human Rights Mechanism or mandates, or the system of special procedures. The special procedure system includes the special rapporteurs, independent experts, and working groups. We have currently 45 thematic and 13 country mandates. Experts examining the situation in, for example, occupied Palestinian territories, Cambodia, the Democratic Republic of Congo, North Korea, and Somalia. These are known as a country mandates. In terms of the thematic mandates, the issues currently under examination include, for example, religious freedom, the right to food, torture, the death penalty, arbitrary detention, disability, rights of older people, or people with albinism. Reporters and the experts are independent and operate in their personal capacity. A mandate requires a reporter or a working group to examine and report on either human rights abuses in specific countries, which it's a country mandate, or to examine a major issue on general concern, which is a thematic mandate. Country visit might be made, but not all states cooperate with mandate holders. Some states do not permit entry at all to mandate holders. Others permit entry, but then seek to do all they can to obstruct the mandate holders' visit. Reports are made on a yearly basis, and there is also an effort to coordinate the work of the mandate holders, although there is quite often an overlap. Now we will discuss UN Security Council. For decades, the human rights were seen as being largely outside of the scope of the Security Council. And human rights protection and promotion of human rights were not mentioned in the scope of Security Council activities. Because of the mentioned early Article 2.7, which state that no state nor the UN might intervene in matters within, which are within the domestic jurisdiction of any state. Other states were unsure about including a set of issues widely perceived as a matter of state sovereignty in their deliberation about international peace and security. But right now the situation clearly changed, and we can easily say that Security Council is also responsible for protection and promotion of human rights. The main UN Security Council is to maintain peace and international security. So Security Council can investigate any gross violation of human rights or dispute or situation which is likely to endanger the maintenance of international peace. The Security Council has also authority to put human rights mandates into peacekeeping operation, or to mandate separate human rights operation. Consider gross human rights violation that are threats to peace and security, as we just mentioned. And this last competence in protection and promotion of human rights is quite controversial. It is right now considered that Security Council is able to establish international criminal tribunals, but this competence is not mentioned in UN Charter. The first international tribunal, hybrid tribunal, was established in Sierra Leone, and the tribunal was established based on the agreement between the Sierra Leone government and Security Council. And then the competence of Security Council of establishment this kind of tribunals were widely discussed. But at this moment, we can say that the purely international tribunals established by the UN Security Council were the Tribunal for former Yugoslavia and the International Tribunal for Rwanda. As mentioned before, within the UN system, The bodies responsible for promoting and protecting human rights can be divided into two categories: the UN Charter bodies, which we just discussed, and also UN treaty bodies. Starting from 1966 covenants, there are a number of other core human rights treaties. Each covenant or treaty sets up independent monitoring staffed by independent experts elected by member states and responsible for overseeing the operation of the treaty. The treaty bodies are as follows: the Human Rights Committee, the Committee on Economic, Social and Cultural Rights, the Committee on Elimination of Racial Discrimination, the Committee on the Elimination of Discrimination Against Women, the Committee Against Torture, Committee on the Rights of the Child, Committee on Migrant Workers, Committee on the Rights of Persons with Disabilities, and Committee on Enforced Disappearances. The main function of the UN treaty bodies, of the committees, but also we have to mention that not every state participates in every mechanism, the principal function is to monitor the compliance with the terms of the relevant treaty by states parties, to monitor implementation and to interpret the convention. The committees also receive state party reports, initial and periodic reports. The committee can issue general comments which aim to interpret and clarify the treaties, or the comments might be on specific issues. The individual communication under the optional protocol. And the committee has the authority to consider complaints made by one state party that another state party is not abiding by the covenant.